Shri Naavi sir, Chairman, Foundation of Data Protection Professionals in India, to deliver a keynote address on this occasion. Please, sir.
Good morning, everybody. I hope if you give me a share screen, I will also perhaps see if I can put up a presentation. But anyway, to start off, let me first of all thank the KLE College, particularly Sharda, who has given me this opportunity to be present here. When we actually planned this particular program, of course, she has put me as technology partner, but today I think it should be more a knowledge partner. Also because technology has to some extent given some problem now. Okay, now when we first planned it, actually we thought that we will be having a physical program. It was sometime around March end, and because of the COVID, we had to cancel that program. But it was a blessing in disguise in the sense that today, right now on the Zoom platform, there are nearly 400 people, and there must be several other people on the live YouTube session. So this kind of vast reach, much beyond Hubli. Okay, if we had held there, only people who could congregate there in Hubli would have had the benefit of the attending this. Now, actually, perhaps the entire India is open to it, and I understand that even people from abroad may be there attending here. So that is one of the positive things which has happened by taking this seminar on the virtual platform. So I must thank Sharda for that, and definitely people behind that, the people from the engineering institutions, should also be thanked for that. My association with KLE has been quite a long association. In fact, when I first started something called the Cyber Law Awareness Movement in Karnataka, it was KLE who actually held my hand at that time. Mr. Mallikarjunaya, who I suppose would also be available here, he was instrumental in bringing out the first cyber law course in association with the a college like KLE. I used to run something like Cyber Law College, which was the first virtual college. When I started that virtual college, many people were not very comfortable with this virtual world, and I had many times received requests, people who will walk into my house and say, "Where is your college?" I used to say that my college is on my computer. Okay, but today, fortunately, this concept of virtual meeting has widened. In fact, educational institutions starting from the KG kind of schooling to the advanced training, they have all gone into the e-education platform. And what we are seeing today is perhaps an indication of how successful has been this transition. Now, apart from KLE Law College, even my association with Mr. Dilip has been a long-standing one. I first met him in Mangalore. That was again a part of my association with the Law College there to conduct a program. And since then, we have been seeing how Mr. Dilip has been progressing in his career. A person who has a lot of academic interest, and in fact, Dharwad and Hubli should be fortunate to have him as the commissioner. In fact, I would have quite been happy to meet him personally, but today at least we are meeting virtually. So, my greetings to him. I also convey my greetings to Mr. Anami. I think he's associated with the KLE IT, and Ganeshwar, who has personally handled the particular program, conceptualizing that. Okay, so what I would like to do in this keynote address is to actually set the ground for the further discussions which are likely to come in the additional sessions, which will be handled by other experts. Some of them have been drawn from our Foundation of Data Protection Professionals, which is a very ambitious program I have set. to ensure that India becomes a cyber, like we worked at one time to be a cyber law aware country, or Karnataka as a state. We are now looking at data protection for the purpose of privacy protection as a very important concept. And I hope Foundation of Data Protection Professionals will contribute a lot into this. That is why 2 years before the act is to come, it is still in the bill stage in the parliament. Joint parliamentary committee is still discussing with experts on what changes can be made. It will become a law. I hope it will become a law soon. But 2 years before this law came into being, we thought that we need to have an institution to provide some kind of a knowledge empowerment to the society, and that's why this not-for-profit Section 8 company was started. We have made substantial progress, particularly because we wanted India to be self-reliant in the field of data protection. The moment we talk of data protection, people will be talking of GDPR as if GDPR is the one and the only thing in the whole world. But we in India would like to say that though Indian culture has always looked at knowledge dissemination more, and privacy was always considered as not that important as in the case of the US and particularly the European markets, we felt that there has to be some effort in bringing out the knowledge of data protection, and for that purpose we actually took up two important steps, which are actually internationally important self-reliant steps. One was to create a certification program for people who would like to acquire knowledge on this particular field, and more so also try to free India from the need to depend on international information security frameworks. We normally conduct audits and other things, very expensive. But when we talk of a law which is applicable to not only big IT companies, but also to government departments, also to educational institutions like KLE, and even smaller businesses, if we want compliance with the law, we need to have an implementation mechanism which is affordable to most of the organizations. Therefore, we thought of creating a India-specific information security framework called Personal Data Protection Standard of India. So the certification and this PDPSI are going to be the two pillars on which the data protection law, when it is passed, will be taken across the country. So that is the purpose for which we started this foundation, and we are very happy to collaborate with academic institutions like KLE and spread this knowledge further. Now, getting more into the topic of the day, we know that most of us as professionals, and including the KLE Law College, we have moved first from law in the traditional sense to cyber law. Okay, so initially lawyers were supposed to be experts in say law relating to properties, some criminal laws, etc. But in 2000, when Information Technology Act came, we started telling lawyers that if you do not know cyber law, you are not a lawyer. You are not fit to be a lawyer, because everything in this world is going to transform into digital form. Whatever may be the offense, ultimately the evidence will lie in the form of an electronic evidence. Therefore, knowledge of cyber law is very, very essential for the lawyers of the day. You are in the field of law education, so most of you are aware that even today, cyber law has not been fully integrated into the curriculum of the law education in our country. I hope the KLE Society will be one of the first such institutions to put it as part of the curriculum. Though Bar Council at one point of time suggested that cyber law should be taught as a say credit program kind of a thing, and some of the people have tried to do it. Basically, for lack of faculty or whatever reasons, most of the law colleges have not been fully able to integrate cyber laws into their curriculum. I hope I am wrong if I am wrong. But we still have the certificate programs which are being run today by National Law School or NALSA. And what I started 20 years back as cyber law college has now gone into most of the colleges. Of course, my cyber law college programs are still continue online. That is a different issue. So people have moved from law to cyber law. Now, after we moved into cyber law, we also found a situation where there was a very close interaction between the so-called cyber law, which we and the other lawyers were talking of, and a certain subject called information security, which was basically the domain of a technology person. If you ask an engineer, he would talk more about information security. He would not think cyber law is part of his domain of study. But soon people realized that when we talk of cyber law, we are talking of a law which is techno-legal in nature. When we talk of securing a message, we immediately talk of digital signature. And if you want to talk of digital signature, you should know about hashing. You should know about asymmetric crypto system. Therefore, there is a very close interaction between the information security area and the cyber law. And when Information Technology Act, of course, when it first came, the objective of Information Technology Act, was to promote e-commerce. So only those aspects were there in the law. Digital signature was part of it. But in 2008, our Indian cyber law actually underwent a very big change. And it brought in a lot of information security issues into the domain of law. So the 2008 version of Information Technology Act had very important specifications, legal specifications on how information security has to be managed by a company or any other organization handling information. At this point of time, I'm using the term information. I'm trying to avoid the use of the term data, though sometimes data and information are used as interchangeable words. So this 2008 Amendment of Information Technology Act brought in a close interaction between the information security area and the law area. Therefore, the engineers who are studying information security in terms of algorithms, kind of encryptions and other things, they immediately realized that I am having an algorithm, I am having MD5, but law says MD5 is no longer applicable, you have to go to SHA-1 or something like that. Or you talk of an encryption, the law is going to question whether your encryption standard is good enough or not. So the technology people started thinking that law is defining what should be the security. So this interaction of the law and the engineering domain started with this recognition that information security is prescribed in law. So far, until that time, information security was only a good practice. So somebody says, I want to be ISO 27001 compliant, and therefore I want to have this firewall, I want to have an IDS system, something like that. But what Information Technology Act did was that it brought a legal oversight into the domain of information security. Therefore, the information security people, who are all engineers, had to study what is there in cyber law. This was the time when we also started a course for cyber laws for engineers. Okay, basically to tell people that cyber law is not only for lawyers who will go to the court and look at a cyber crime, discuss with the police, that law enforcement and other things. That is one part of cyber law. But the other part of cyber law is how to apply cyber law for proactive compliance so that the so-called cyber crimes do not happen at all. So security is to prevent the occurrence of data breaches or cyber crimes. If cyber security is efficient, then the number of cyber crimes will come down. Today, if you have any cyber crime, you can say that behind that cyber crime, there is some kind of a negligence on the part of the information security people. Now, after this COVID brought in this forced lockdown, between January this year and March or the current time, the cyber crimes are supposed to have more than tripled. Now, why is that happening? First of all, of course, because more number of people are going digital, so the more access to internet, that itself is the reason for increased cyber crimes. The other aspect is many of the companies were forced to switch from working within a premises to this so-called work from home situations. Earlier, we had a concept called BYOD, that is, bring your own device system. Some companies had a system that you can bring your own laptop, you can bring your own mobile, connect it to the corporate network. We will give you adequate security. Some of those companies had developed some system of information security even when the employee does not use a secure corporate, let us say, computer, but used his own personal computer, which he takes it home afterwards and in which his children will be playing games, somebody else will do some personal work. The same laptop, tomorrow he will bring it back to the office and then connect it to the internet. So there were security issues there, but companies which had introduced BYOD were to some extent ready for this so-called work from home situation where the access to the corporate networks moved from a secured, you can say, building of the company to the individual homes. But a large number of other companies who are not into BYOD system were not ready for this work from home situation. In fact, they first allowed the people to go home and then said from your home you can connect to the corporate network. That created a security situation in which sometimes the compromise of security in the home could affect the security of the company. So, you have all heard of this so-called ransomware attacks. Okay, one of the big companies in India was also affected by this ransomware attack. We don't know how this ransomware attack originated. Basically, it originates out of a virus which is dropped. Now, in the corporate environment, we have a very efficient firewall, so people will not be able to drop virus there. But when the employee is working from the home and in a situation where a family is having one computer, so morning perhaps the child has to log into his school account, the wife has to log into her, let us say, shopping account. In that kind of a scenario, it was difficult for this employee to have a control over the use of his own computer. Therefore, the possibility of viruses and other things coming into the person's home computer was higher. So this increased the risk of what we call as endpoint security. Okay, so we can secure our corporate network because we have got the resources, but how do we secure the endpoint where thousands of our employees are actually working from their own devices? That was the reason why many of the cyber crimes increased. Of course, to some extent, people who are not earlier using any online payment systems were forced to use online payment systems. Online banking was being used. So, both because the usage was there and also because the security systems were not able to immediately address the new security paradigm of work from home, we had an enormous increase in the cyber crimes between January and now. Now, in this scenario, the security people are realizing that there is an impact of Information Technology Act and other legislations on cyber security, and this law and security coming together has become more intertwined. And I'm happy that you have got KLE IT being involved in this particular program, because the engineering students also should realize that they need to coordinate with the lawyers, and together they have to work out the cyber security system. Even those people who are in forensics, what is forensics? Forensics ultimately is creating some evidence for the purpose of admission in a court of law. So if a forensic scientist says that I did so many wonderful things, extracted a log record, etc., all that will be useful only if that log record is acceptable as evidence in a court of law. So a forensic person who is a core engineering person, if he does not know cyber law, at least to the extent of section 65B of Indian Evidence Act and something surrounding that, he will be like a person who does his operation well, but it is of no use. Okay, so he may create a lot of evidence, but when it's taken to the court, somebody may ask a question, is it section 65B certified? This person may say, I don't know what is section 65B certification, so his evidence will be perhaps rejected. So this sort of interactivity between technology and law has now assumed more and more importance. Now, even this techno-legal implications, you can say we realized this a couple of years back, so we started calling security as techno-legal security. Normally, security people use the terminology confidentiality, integrity, and availability, CIA principle. We who called ourselves as techno-legal people said that you have to extend these three layers of security to authentication and non-repudiation of data. Then only this 5-layered module would perhaps be the techno-legal security model. So these things happened a couple of years back, and this movement from law to cyber law to cyber security happened. What is happening today is that this transition has undergone another change into an area called data security or data protection. So the cyber security is now undergoing a slight change into data security. When we talk of cyber security, sometimes we feel security from internet related threats. When we talk of data security, our focus is more on what lies ahead of us in our computer, that is data. That data may come from cyberspace, or I myself may type on my computer, that is different, but ultimately there is a data, and that data has to be secured, both from attacks from cyber as well as any other kind of attacks. So this thought of what we called as information security under CIA principle needed a slight tweaking. That was the time when the concept of privacy protection gained some kind of importance in the discussions. This privacy is actually something which the lawyers brought to the discussion table. Okay. Now, otherwise, the technology people were happy looking at access control systems, encryption systems, and to some extent controlling the encryption with a proper key control system. So they were perhaps looking at how do I secure the information residing inside a computer by having a firewall, and the firewall will take care who will come in and who will not come in. Okay, so I provide some kind of decision rules for the firewall and try to manage that. And some of the organizations went one step further. I will have an intrusion detection system like intelligence. I will try to monitor who is trying to come in, and based on which I will change my security features. So this kind of a thing was going on, and security people were gradually moving from access control based on a verified access. That is, normally, when we talk of access control, we give a password, login ID, and tell the person that you use this login ID and password, you will be given entry to the system. Now, cyber criminals were very easily capable of overcoming this password-based system. Of course, Indian law never recognized password-based access as legally acceptable. Right from 2000, we are talking of digital signatures. But technology people are resisting that legal position because they don't want to switch over to digital signatures. They want to remain in password. And the only concession they gave to the legal field is that we will introduce what is called a second factor authentication through the so-called OTP. So therefore, if password is considered insufficient security, we will introduce an OTP, in which case you will have to have a second password which comes through your mobile system or through the email system. So the only concession security people gave to Information Technology Act was upgradation of security from mere password to password plus OTP. But all of us know that cyber crimes continue to happen, banking frauds continue to happen, people are able to impersonate these passwords. Therefore, this verified access through passwords was not a successful cyber security tool. In fact, in USA, NIST has already degraded even the OTP system. Okay, India, we are still using OTP system. RBI still supports OTP as one of the criteria. And in fact, when Reserve Bank of India in the year 2011 was considering the Gopalakrishna Working Group Committee report, a lot of people in the technology wanted to get a legal declaration that OTP means electronic signature. Fortunately, this did not happen. The cyber law provisions prevailed, and OTP remained outside the system of digital or electronic signature, though we accommodated the Aadhaar based e-sign as one of the additional features of authentication. But today, the security people have made another innovation which is far better, which is called adaptive authentication. That is, your password alone will not be considered good enough. I will watch. Are you coming from your native place where you regularly log in, or you are coming from a different place, or what is the kind of transaction you are doing? So far, you never did a transaction about 10,000 rupees. Suddenly, you want the bank to transfer 1 lakh of rupees. So, such cases, it will recognize that there is an additional risk in terms of this particular transaction, and immediately it will say it will not allow you to enter with your password. It will start a higher level of verification, which is what we call as adaptive authentication. Maybe in some cases that will be just one small step ahead, where they may say that I want to have more verification from you. What is your date of birth? What is your mother's maiden name, etc., etc. That is one way. Maybe some other ways. In some cases, the bankers are very careful. They even call the person over phone, something like that. So from authentication to adaptive authentication, people have moved, and even higher level of security. Now most of the people try to link a registered user's device to the authentication. For example, if I am logging into Google regularly from my Windows computer, and now I want to use your computer to log into my Gmail account, Gmail will immediately recognize that this is an unusual transaction. Therefore, I have to ask you a question. Why are you coming from a different kind of a computer? So they will introduce their own second factor or multi-factor authentication. So this device being integrated into the authentication process also happens in the mobile kind of a thing. That is, at the time of registration, the mobile ID, which may be IMEI device or the BIOS ID in the case of computer, gets integrated into the system of authentication. And in fact, we also know that device-to-device encryption sometimes also embed the device-related ID into the encryption key. Okay, so these are some of the innovations which the the security people did. However, we all know that about 2 years back, we had the grand Punjab National Bank fraud in which 11,500 crores was lost. And that is a classic case of how information security on paper, if it is not implemented, it is of no use. For example, in this Punjab National Bank case, as most of you are aware, the problem arose because there was a CBS system, which was the real banking, core banking system. There was a system called SWIFT, which is a messaging system. So a bank had the authority to send a message for fund transfer to another foreign bank or something like that. Any common security professional who is a domain expert in banking would have immediately said that if you are using a SWIFT message to create a liability on the bank, that liability should be immediately recorded in the CBS system. I am a banker in my first part of my career. we know that even when we give what we call as non-funded credits, we always create a contingent liability in our balance sheet so that we don't miss that I have given a guarantee to so and so. The guarantee may not mature, I may never pay the money to them, but I want it on my balance sheet. Of course, bankers will also try to take commission. In the case of this Punjab National Bank, what happened? The SWIFT system worked independently compared to the CBS system. Whoever integrated the CBS system into the banking, that technology person did not understand that if you don't integrate all liability creating applications into the CBS system, there will be a parallel banking happening in the other area, and frauds like what happened in the Nirav Modi case could happen. And in this particular case, there was further security failure because the access to the CBS system or the SWIFT system, which should have been integrated to the network of the Punjab National Bank, the computers of the authorized persons, that device integration also was perhaps not there. Therefore, the fraudsters were able to log into SWIFT system from outside the banking premises and commit the frauds. So, the information security, which graduated from normal access control to adaptive authentication, including the device ID integration, still did not function because the information security people looked only at technology. They never looked at the misuse of technology, which was the subject matter which normally people who are studying law will be the first to recognize. Now, same way, when we come to encryption, today we are talking of encryption as a very strong part of security. Okay, we always talk of symmetric encryption, asymmetric encryption, key length being higher. We will use VPN. This is the sort of language which we use in cyber security. But today's trends indicate that these are all in the past. Okay. What we now have to look at is not only encryption of data at rest, data in transmission, both of which are attended to by the encryption standards. Okay, I can encrypt my cloud data. Whenever I am sending you the email or something like that, I can encrypt it so that from my device, particularly if I use a PKI based public key based encryption, using the public key of the addressee of an email, then the message which I am sending gets encrypted in such a manner that it cannot be pilfered along the way. It can only be decrypted by the person who has the private key of that particular key combination. So, data at rest and data in the transmission, to some extent we know how to encrypt and secure. But in the cloud system, what happens is people want to sit here, put the data in some remote cloud, and when it comes to processing of the data, the applications also are remote based sometimes. Sometimes some applications are here. So when I want to process a data, the data has to move from cloud to my computer, get processed here. After the process is over, again it is stored back in the cloud. So transmission you can still encrypt. After it reaches the other end, you may encrypt. But while data is under process, encryption will have to be taken out because you have to take it into the plain text form, then use the application, then re-encrypt. Decrypt, process and re-encrypt is a process which most of the people use. Now, in terms of security, particularly in the increased use of cloud as a base for storage, we need to develop some system where encryption continues even when the data is under process. Now, this is what we call as homomorphic encryption. A lot of research is going on in this, and I feel the engineering people who are listening to me should think of doing some research on this homomorphic algorithms for encryption, because we in the field of data protection are looking forward to affordable solutions of homomorphic encryption, so that while we continue to use cloud because cloud is beneficial for the business in terms of cost reduction, scalability, and so many other things. But it is always weak on security. Now, if we can develop this homomorphic encryption, some people try to develop something called near homomorphic encryption. That is one area where technology has to advance in terms of cyber security. The other place where encryption is likely to need some support from the engineers is that there is going to be shortly more and more of what we call as quantum computing. The classical computers will have to work along with the quantum processors. The quantum processors, okay, basically the difference between the classical computing and quantum computing is in classical computing, data is held in binaries, zeros and ones, and it is stored on a, let us say, a magnetic surface or optical surface. You can recognize that this particular pixel is 0, the next pixel is 1, something like that. Whereas in quantum computing, the data holding entity is not a magnetic surface, it is a nucleus of a particular element or sometimes even an electron. How does the nucleus or electron hold data of 0 and 1? What quantum physics does is, if the electron is spinning in one direction, I will consider it as 1. If it is spinning in another direction, I will consider it as 0. So, the spin direction of electrons and nucleus is considered as the 0 or 1 state, so that the binary language continues to be applicable in this quantum processing. There are, of course, technical issues in the sense that one single electron can be either in one state or 0 state. There is a probability of it being 0, probability of it being 1, which is used in computing, that is quantum computing. Now, in terms of usage, quantum computing is very, very powerful. It can have lot more transactions per second compared to the classical computing. Therefore, all our encryption systems today, which are not capable of being, you can say, broken through a brute force attack, can be very easily broken by quantum processing. Therefore, the so-called encryption today, we say 1024 bits, elliptical curve and all those things, they become meaningless if the hackers start using quantum mechanics or the quantum computers for the purpose of breaking these passwords and encryptions. Therefore, the next generation of technology development in cyber security will have to be on how do we quantum proof the encryption algorithms. So, this homomorphic encryption is a near immediate requirement. Then this quantum proofing is a requirement which we should be ready within the next 5 years. So, cyber security people should look at within the next 5 years mastering homomorphic encryption and at least being able to get into this quantum proofing of our algorithms. So this is something which I would like to leave for the thought process of the technology people who are attending this program, because cyber security is part of the discussions of this webinar. Now, if we move to the second part of this webinar, which is the data protection. This data protection is the concept which we are now talking of in terms of the proposed bill which is coming up, which is the Personal Data Protection Bill. And this particular bill focuses the what we are so far calling as information security, from data to the person behind the data. Okay, even in techno-legal security, we used to tell this, that cyber law tries to secure the liability of the person who is the owner of the data. Now, that focus is going into a further deeper level, because here what we are saying is, certain part of data which has an identity parameter, that is data which has an identity parameter like the name, email address, phone number or something like that, that together we call that as personal data. Okay, so data becomes personal when it is associated with an identity parameter. Now, securing this personal data is considered as the exclusive domain of data security. See, so far information security tried to secure both personal data and non-personal data, corporate data, and any other form of data. Everything should be held in confidential form, integrity has to be maintained, availability has to be maintained. This was the focus of information security. But now, out of this data universe, we are plucking out one set of data called personal data. And we are making a separate law in which we are saying that this personal data requires some special attention. Why does it require special attention? Because the protection of this personal data is directly related to the protection of the privacy right of an individual. India is a democratic country, and as a democratic country, we consider that privacy is a very important democratic right. Our Supreme Court in the Puttaswamy judgment has said that privacy right is a fundamental right of the citizens of India, and therefore the government has to take all steps to protect this privacy. And the judiciary has recognized that today when we talk of securing the privacy being a concept which is not easily understood. So privacy, we say, is a state of mind. Okay, a person may feel that he is left alone. That is what we call as privacy. Now, how do you know what I will feel as being left alone, as different from what, say, Sharda Patil thinks to be left alone? What is the meaning? So, from individual to individual, the feeling of what is privacy will be different. Similarly, for the same person also, what is privacy or my expectation of being left alone right now will differ in another 2 hours. Okay, after I'm finishing this, I want to be, for example, relaxing, and at that time I would not like anybody to disturb. Right now, I don't mind if 350 people or 400 people are ahead of me. They all know who I am and what I am doing, what I am speaking. So, in fact, now I want them to know who I am and what I am saying. But 2 hours from now, I may say I want to go and relax. So, this feeling of being left alone differs from person to person, and it differs for the same person from time to time. Now, if Supreme Court says both are right to privacy and you have to protect it, make a law. Okay, it asks the government, make a law to protect privacy. Now, what is privacy? Privacy is a feeling to be left alone. What is that? I don't know. Different people think different things. So, how do we make a law which is uniform for the country, for all citizens, for all time? Okay, that is the challenge of this data protection laws. So, when we are trying to define a data protection law, there are so many people who do not want this law to come because in the guise of protecting privacy, they are actually preventing the law from being made at all. For anything and everything, they will raise an objection. If necessary, they will go to the Supreme Court and challenge a provision. So, the law on privacy or privacy protection has been pending for last several years. In fact, those of you who are aware of the developments, in 2006, Information Technology Act Amendment Bill was presented in December 2006. Simultaneously, a Personal Privacy Protection Bill 2006 was also presented. In fact, at that time at KLE Bangalore, we conducted a seminar exclusively on that because the bill was ready to be passed in the parliament. But ITA 2000 got amended. The 2006 bill became reality in 2008. But this personal privacy bill never saw the light of the day. It went down. Now in 2018, it surfaced again. This was post the Puttaswamy judgment because Supreme Court directed that India must have a robust law on privacy. 2018 version also did not find a place. 2019 version is what we are discussing. So, from time to time, privacy law is being discussed. Every time there is always an objection about what this can do, what this cannot do. The reason is privacy as a concept is itself so complicated, making a law to protect it is a near impossibility. What is a near impossibility? We are trying to codify it into a law. And even there, what we are trying to do today is, I don't know how to protect your privacy because I don't know what you want. So, what we are trying to do is, let a person give his choice. Choice of what? Suppose there is a personal information, your name, your email address, etc. You are giving it to me. Please tell me how I can use it. Depending upon what you say, I will collect that information and then use it as per your choice. So, protecting that choice is today considered as protecting the privacy. Since information today lies in the form of data, this privacy protection becomes the protection of the personal information which by choice a person has given to another processor for the purpose of processing. So, the right to privacy, which is a democratic right, which is sought to be protected, is tried to be protected by protecting the data related to the identity of a person. And that is how the privacy protection becomes part of the data protection. And today, every organization which is handling data, which is an IT function, have to look behind their back and then say that, okay, this data is personal data, this data is not personal data. If it is personal data, then I have to look at what the law says about protecting the personal data, and I have to see in my system design, privacy should be there by default and design. So I cannot remain as a CTO or a simple technology person and say I will do something with the data. The moment data becomes personal data, there will be another officer sitting in your organization called a data protection officer who will say, without consulting me, you cannot develop an algorithm, you cannot develop a process, etc. because the law says that DPO is the person who will supervise and monitor the technology. Therefore, in every organization, there will be a person called the DPO, Data Protection Officer, who will report directly to the CEO or sometimes even above the CEO directly to the board, and he will be supervising all the technology related activities and then poking his nose in each and everything because law gives him the power to do so. That is the importance of this data protection law, because data protection law actually imposes a regime of compliance on an organization processing personal data to say that this is what can be done, this is what cannot be done in respect of personal data, and to monitor that I will have my representative sitting inside your organization called the DPO, and if you do not comply with whatever provisions I am having, then I reserve the right to perhaps impose what is called administrative fines. Administrative fines in data protection law are important because the maximum level up to which such fines can be levied could go up to 4% of the global turnover of a company. You can imagine that most of the companies, particularly in the retail sector, never have 4% as the gross income. But here the administrative fines can go to 4% of the turnover. Okay. That is why GDPR, when it first came into the reckoning, created a stir in the marketplace, because GDPR said that if you are not compliant with GDPR, you are liable for 4% of the global turnover as the penalty, or of course 20 million euros, but whichever is higher. So ultimately 4% could become higher. And GDPR also said that there is extraterritorial jurisdiction for our this thing. This is applicable even for data processors sitting in India if they are processing data from Europe. So that is why GDPR became such a important legislation to be worried about. Now in India, we are now coming up with a sort of a law which is not much different from GDPR, but it is different. In terms of administrative fines, this also talks of 4% of the global turnover if you are not compliant. Therefore, every CEO, every CTO, every CISO should understand that they cannot remain in the field as technology persons unless they understand what is there in this data protection law and try to ensure that compliance to data protection law is part of the technology architecture in a company. So therefore, this integration of law and technology which I was talking of has gone one step further. Earlier in cyber laws, if something goes wrong, if there is a data breach, then somebody goes to the police registers an FIR, then starts an investigation. Then only when there is a cause of action, there will be the law which will be invoked. Whereas in this data protection law, this is a law of compliance. In Information Technology Act, we had a section called 43A, which said that a body corporate having sensitive personal information should follow certain reasonable security practice. There was one section like that. And there was a concept of due diligence. What this data protection law is doing is, it has expanded this one single section into a big act, and it says that proactively every organization, including the KLE, including any other school or any other organization, needs to comply with the provisions of this Personal Data Protection Act, whichever when it is coming. And if you don't, then whether there is any crime or not, whether there is a data theft or not, I as a data protection authority can impose a fine on you, which can be running to several crores. This is the importance which the data protection regulation has today as a compliancy related law. Because it is compliancy oriented, it has to be complied with, and even when there is no data breach, this law can hurt a company. For example, if the law says that there has to be a data protection officer appointed and you are not appointed the data protection officer, that is sufficient. So that is why this knowledge of data protection law, as it is emerging now, is a prerequisite for any professional in the field of IT or in the field of law to be in the professional market. Now, we are thinking that this ITA 2000 will be there, 43A will go, but it will be replaced by this. So ITA 2000 will coexist with the Personal Data Protection Act. But the legal scenario is not going to end there. Now, the government is thinking that, okay, there is a data universe. From that data universe, you have plucked out the personal data, created a law for that. Now, what happens to the remaining thing, which is called a non-personal data? Whatever from the whole data universe, whatever you remove as personal data, remaining is non-personal data. Is there a law for non-personal data? Now, the Information Technology Act says that any kind of vandalism and other things, misuse of this data, whether it is personal or non-personal, there is an offense and other punishments. A Personal Data Act will only look at compliance issues, but the main offences in terms of criminal offences will lie with the ITA 2000. But there is also a thought process which you have been talking of, that is, data is the new oil. What do we mean by calling data as the new oil is, it is an asset for an organization and you can actually create a lot of value out of data. So therefore, the government has now thought that after taking out the personal data, what is remaining is non-personal data, ensuring that it is not misused in terms of cybercrime, etc., because ITA 2000 has a deterrence for that. What else can we do with non-personal data? Should we just leave it out like in an oil extraction industry? You take the oil and then whatever is remaining, you just burn it out, or in the sugarcane industry, leave it as molasses or something like that. Is it the proper way you can use the residual system? What the government has now thought of is, we will have a new law called Non-Personal Data Governance Law. This is not protection law. It is governance law, because protection is already there in ITA 2000. So this non-personal data governance law, presently one committee had been formed by the government called Chris Gopalakrishna Committee. It has given its report. Right now it is available for public comments. Today was supposed to be the last day for public comments. Fortunately, they have given 1 month more time. This Non-Personal Data Governance Act will have lot of opportunities for technology people. Therefore, if engineering colleges are sending out engineers into the marketplace, you have to train them to understand what is personal data, what is non-personal data, how to be compliant with ITA 2000 and Personal Data Protection Act, because they will be here today and tomorrow. ITA Act is already there. PDPA, it may come in a couple of months, but in the next year or two, there will be this Non-Personal Data Governance Act, and most of our engineers are going to work in an organization where the CEO will ask, what are you doing with this data? Are you getting me the value out of it? That part of it also has to be taught to our engineers. So our educational system has to undergo a transition from whatever it is teaching now to teaching techno-legal legal provisions. And in the techno-legal provisions, please understand that study of data protection as well as study of this non-data governance, they all become part of the requirement. So this is the importance of what we are discussing today, cyber security along with data protection, to an audience who are both perhaps law people and also technology people. I hope the management people could be there and others could also be there. And the purpose of this particular seminar is to provide this kind of a knowledge base. So that is what I think is the background under which you have to look to various technology sessions, technical sessions, where we will go into much deeper aspects of what is there in PDPA as of now in the bill, and security people will perhaps discuss something about cyber security particular elements. But together, this 2-day virtual conference will perhaps initiate the audience into this new world of data protection, which is going to create a lot of employment opportunities. The reason why we want to have certification programs, we want to have information security framework. When I say information security framework, some of you may not understand. There is this ISO 27001, ISO 27701 as frameworks. We are creating a substitute for ISO 27701. You can imagine how big is the challenge. Say ISO is an internationally accepted standard. FDPPI says that we will have a standard called PDPSI, Personal Data Protection Standard of India, and the SMEs who cannot afford to have an ISO 27001 and 27701 as audit frameworks need not worry. Let the large organizations pay whatever they want and have an ISO 27001 audit. You please look at PDPSI. That is as good, if not better, than the ISO 27701. That is the objective of this Foundation of Data Protection Professionals, for which we are looking forward to the legal professionals coming out of the law colleges and the engineering professionals coming out of the engineering colleges to come together and take up this field of data protection. If you call data protection as a career, non-data protection governance as another career, that will normally come into the management cadre also. All MBA colleges will have to shift to teaching how to govern non-personal data in a manner in which it is beneficial to the organization. So engineering colleges will prepare people. So engineering MBA on non-personal data governance is going to be a great career opportunity. And this, apart from cyber law plus data protection law awareness will be a career building opportunity for the legal people. And this 2-day seminar should give you some kind of, you can say, initial understanding of these two fields. So that is something which I wanted to share with you. Maybe I would have taken more time, which Mr. Dilip actually passed it on to me. I hope it was useful. So thank you.